Ready to proceed, sir?
Yes, sir.
Well, Mr. Schnitker, was there ever, during this interview, what was your understanding of Chloe's death, how she died?
There was an altercation between her and Kelsie. I believe it started in the entryway to her bedroom. I think there was some, in her words, use of the pajama pants around her neck, possibly causes unconsciousness. And then I think as she stated, she placed the child on the bed, and I think the assault continued on the bed.
Prior to Kelsie noting that, was there any certainty you had as to, at least from the investigations, what may have occurred?
I don't think we knew as much what did occur, how the actions and injuries happened to Chloe's as much as we did that our belief that what her initial version wasn't accurate.
Was that what informed your decisions as you proceeded through this interview?
Yes.
Now, why challenge her so much when she denied having any involvement with Chloe's death?
I would say strong denials like that are common in interviews and interrogations. I don't think I'd be doing my job if I took just a simple "I didn't do it" or "I'm not the person responsible" as a end of the interview. It definitely warrants some more continuation and more conversation.
Why did you focus so much on the pajama pants?
The pajama pants were a focus of the interview, both interviews, because Kelsie brought that to our attention. In the 911 call, she says the pajama pants were around her neck. That was the mechanism of her death, as she reported it. So as an investigator, that item's important to us because it was important to her.
Just because once again, the audio is somewhat muffled, was Kelsie's first reaction to you telling her that Chloe did not die by a hanging caught on the video?
Yes, it was.
Now, when, if ever, did you suggest to Kelsie that she use Chloe's spaghetti straps to choke her?
I think we talked about her spaghetti straps, but I don't believe I used that as the mechanism that she was strangled or choked.
And was there ever a time where she then said she did so with spaghetti straps?
She alluded to the shirt being around her neck, but she did not go into detail on that.
And who first mentions that Chloe flooded the bathroom sink in the past?
The defendant.
When, if ever, did you explain to Kelsie how eyes behaved during or after strangulation?
I never did.
Who first noted Chloe's lips were blue?
The defendant.
Who first mentions how wobbliness or shaking happens during a strangulation?
Kelsie Thomas.
And who first suggests that Chloe bounced on her bed during the strangulation?
Kelsie Thomas.
Who first noted that Chloe gasped during the strangulation?
Her mother, Kelsie Thomas.
Now, at the end of this, your questioning, was there a break that we saw in the video?
Yes, there was.
When you resumed questioning, there was someone who came into the room. Who was that?
At some point, you see a female. That was another DCI agent, Laura Myers.
And at least during this interaction, from beginning to end, once Kelsie Thomas stated how she choked Chloe, was there any recantation?
No.
One moment, Your Honor. At this time, the state would seek to submit State's Exhibit 84 into evidence through stipulation.
No objection, Your Honor.
State's Exhibit 84 is received.
May I approach the witness to have him publish it through reading?
You may.
Thank you, Your Honor. Sir, providing you with remarks as State's Exhibit 84, if you could read that for the jury.
It states, family, I just want to say how terribly sorry I am right now. I love Chloe so much and never thought anything like this would ever happen. I just wish more of you would have helped me when I asked or tried to get me the help we all know I needed. Please keep her memories alive. let Phoenix know I love him and that I'm very sorry this happened. I'm sorry I lied to everyone. I was so scared of what I did and what would happen. I don't blame you guys if you never forgive me. I wouldn't either. Love you all so much, Kelsie.
And is that the letter we see her write on video, sir?
Yes, that was a letter she wrote after we left the room.
I'll pass the witness, Your Honor.
Cross?
Thank you, Your Honor. Good afternoon, Agent Schnicker.
Good afternoon.
Just to kind of follow up with some of the topics that we were just discussing. You were asked about Kelsie Thomas's reaction when you told her that Chloe was not hanging, correct?
That's correct.
Prior to that, you and Michael Sieren were already being accusatory. In fact, at one point, Sieren had to tell her, yes, we are accusing you, correct?
That's correct.
You had said that Kelsie had first mentioned hearing a gasp, correct?
I believe so, yes.
That recording's not going to demonstrate that you had actually asked prior to that whether or not she had heard a gasp, or do you recall?
I don't recall.
Okay. The letter that you just read to the jury, that's the letter that the jury observed Kelsie write at the end of her confession, correct?
That is correct.
And that letter doesn't contain any specifics or anything about what happened. It's just generally she's apologizing to her family, correct?
I think it, as I read it, is how she wrote it.
Okay. Now, in the beginning of your testimony, you indicated that on July 20th, you came down here, you were essentially debriefed, but you felt that the Atomo PD did a good enough job in talking to the people that were around, and at that point, you're waiting for the autopsy to come in, correct?
That's correct. I think the initial investigation that they had done sufficed until we had that information from the autopsy.
Is that at that point you learned that Cloe Chandler's death was initially found to be unsuspicious or non-suspicious, correct?
I believe that's how it was originally reported.
Now, during the first interview, and again, this is pointed out, but I'll just make the jury clear, that first interview where we've seen several clips that accounted for about 45 minutes, that was about 45 minutes of the entire about 6 hour or 5.5, 6 hour interview, correct?
That's correct. The first interview is approximately 6 hours.
Okay. And by my notes, for about the first, and I'm just ballparking here, but for about the first hour and a half, you're just engaged in this free narrative where you're letting Kelsie tell you whatever it is that she wants to tell you, correct?
It's correct. For narrative, or she does the bulk of the talking.
Okay. And do you recall in that first interview, you and Investigator Sieren are asking her about the positioning of Chloe's neck and wondering how her head would have just come out of the pants, correct?
Yes, that's correct.
And do you recall telling her you were assuming that there would have been some flailing around going on and she would have released herself somehow?
I don't recall that term. I know that we spent a lot of time on how she was removed or taken down from the dowel rod.
Okay. If that recording indicates it is reasonable to assume she would be kicking and flailing around, you wouldn't have any reason to dispute that recording, correct?
No, the recording would be accurate.
Now, I know that during that first recording as well, there was some question about Kelsie Thomas's whereabouts throughout the day. Do you recall that?
Yes, I think like her timeline of the chain of events for that day.
Right. I mean, even before she came home and before Aaron Thomas left the house that day.
Yes.
Okay. And part of that had to do with Kelsie had stopped at Walmart, and ultimately the state was able to find video footage of her stopping at Walmart, correct?
That's correct.
That was a fact that Kelsie didn't relay to you in that first interview. She didn't remember it, correct?
I'm trying to recall if she stated that in the interview. I know that She did, and I'm aware of the video. I don't recall if that came from her, if we found that after. I don't know how we got to Walmart.
If she would have said, I went to the store, maybe Hy-Vee, and then ultimately it proved to be Walmart, does that refresh your recollection?
It must. At some point she said something that would have made us travel to Walmart to look for video.
And ultimately that wasn't important as far as whether or not Kelsie Thomas was guilty or not guilty of what she's accused of, correct?
It's just established her timeline for that morning.
Throughout both of these interviews, you are asserting to Kelsie Thomas that the signs don't lie, that certain things just didn't happen in the way that she said that they happened, correct?
That's correct.
And you're relying quite a bit on the science. You're confronting her with the science, correct?
I think the science and I guess my personal experience and her statement matching up with what we knew at the scene.
Okay. Now, something you and I are aware of, but maybe the jury is not, there's nothing illegal with officers lying to people in order to get them to give them information, correct?
Right, we can lie during interviews.
Okay, and so not all the information that you're providing to Kelsie Thomas during her 14 hours of interview was accurate information, was it?
I don't recall in the interview where I lied to Kelsie. I believe I stuck to my understanding that the position that she stated that she found Chloe in did not match up with the evidence. I don't believe that would be a lie.
There was never any expert to explain that there was never a knot hiding those pajama pants like you asserted to Kelsie Thomas?
I don't believe that assertion was made.
Okay. This may take a moment, Your Honor. Your Honor, if we could briefly recess the time of video, not a transcript, so I can pull this up.
Members of the jury will take a 10-minute break. Please remember all the prior admissions. Keep an open mind. Don't talk to anyone. Pay no attention to media accounts. Don't do any investigations.
This is actually no, we don't transcript the first one. You all have me listen to it then.
Just trying to help. No, I know. I just was when we didn't have.
No, we didn't order one.
Oh yeah, we did.
Not that it helps. No, I don't have that issue that you told me about Adobe.
They don't have a
No, I know, but I might be able to
Done.
switch a term.
This is the only, this is the last of the batch, so we'll have the transcript of the last 446, 33, 447, 10, something like that.
I haven't missed it yet.
When you say 40 and 16? On the
On
L3.
the KT1, the continuance with you.
Oh,
Oh, we're not the,
so this is our,
this is the whole one, we're not telling.
so the L3.
It's not on.
Got it.
Okay, so,
Yeah, if I submit that to the, what are you going to tell me if the television or not? I don't know.
well,
It hasn't been submitted yet.
so you're telling her, well, we got these criminals, they told us what to do,
Right, so when they
And if
look
they're
at these,
telling you that there's never been a knot.
yeah, if they look at these
pants,
pants and tell me there's never been a knot in this pajama pants.
I'm not gonna believe them.
Right, right. But
So,
it
I mean,
didn't say,
okay, well, I'll rephrase.
yeah, I think our
I'll rephrase.
question was, they
Okay.
didn't say, I've analyzed these and there's a knot, there's not a knot.
Okay, that's fine, I'll rephrase.
Did you need to see it? I just want to see if the jury said it. If
Yeah,
you're okay with it. Everyone may be seated. We're back on the record after a brief break and ready to resume with cross. Go ahead, Mr. Rose.
Thank you, Your Honor. Agent Schnicker, while we're on break, you had an opportunity to review a portion of the audio and video recording of that first interview, is that correct?
I did.
And do you recall what I was referring to with my question now that your mind has been refreshed?
I did.
And what do you recall telling Kelsie Thomas in that regard?
Sure, I was explaining to Ms. Thomas that we will submit items to the lab and there's possibility of what these criminals could discover. Is it possible that they could tell me there was a knot in that pants? Is there not? That's my understanding of that audio clip. At that point, no testing had been done on any of the items yet.
So it's your position you did not assert to Kelsie Thomas that those pants would not hold the weight or that the science would not show a knot?
I think there's two questions. I believe that I asserted to her several times that I did not feel that those pants or that the science is going to show that it could have held her weight. As far as the knot, again, I may have alluded to her that they would be able to tell me if they can or cannot, if there was a knot, that could be a possibility. Beginning that testing had not been done yet.
Okay. Was there ever any testing like that done?
The pants were sent to Trace, which is the section of the lab that would do that. I don't recall the results since the story changed. I don't know if that was as important later on in the investigation.
And likewise, there was never any stress test done on those pants to determine how much weight they could hold, correct?
No.
After your first interview with Kelsie Thomas, she agreed to come back again the next day for another interview, correct?
Yes, initially it was set up for the following day.
Okay. And Kelsie Thomas actually arrived at the law center not knowing that there's a scheduling conflict on the state's part, and she was turned away that day, correct?
I don't recall. I know that there was a scheduling issue and we did not interview her on that day, but I don't know if she showed up at the police department or not.
Okay. Would you like to refresh with your report?
Sure.
Do you have that available?
I do not. I'm sorry.
Okay. Now, at the end of your direct examination, you had indicated that a female DCI agent, Laura Myers, had come into the video there at the end, correct?
That's correct.
That's the person who also conducted 5 hours of interviews with Kelsie prior to your and Michael Sieren's interview, correct?
Yes, she did have a conversation with her prior to our interview.
And before Kelsie made any admissions, and you were aware, the day that she made the confession was the day of Cloe Chandler's visitation, correct?
I became aware of that, yes.
Okay, she actually mentioned that a few times, that she had a visitation she was hoping to make, correct?
I know she did mention it. I don't know how many times.
Okay. And at one point she says, I have a visitation I need to get ready for, can I leave? Do you recall that?
If that's in the transcript, I wouldn't disagree with that.
Okay. And you actually mentioned in your direct testimony sometimes she would grab her keys or ask to leave, but she really never took that opportunity, correct?
That's correct.
You had testified about how the doors were open and she was free to leave at any time, correct?
That's correct.
Do you recall what response you would have had to her either asking to leave or suggesting that she would leave?
Are you saying what my response may be or what my response was?
Do you recall what your response was?
I usually either say there's a door or you can leave, it's not gonna change things. Those are
Okay.
usually my statements.
If what you would have told Kelsie Thomas generally was that this isn't going away, that the investigation is going to continue whether you cooperate or not, does that square with your recollection?
That would sound accurate.
Okay. And certainly throughout the portion that the jury saw, she's telling you that she thinks you guys are harassing her and she just wants you to leave her alone, correct?
That's correct.
In fact, I think in that first interview, she indicated she'd agree to that second interview because she just wanted you guys to leave her alone, right?
Again, that's the statement. I'm not gonna disagree if it's in the record, but I don't independently recall that.
Okay. And at the point that you finally made contact in the first interview with Kelsie Thomas, she had already been interviewed and in contact with law enforcement numerous times that you were aware of regarding this specific issue, correct?
Contact prior to the first interview on that Tuesday?
Prior to your first making contact during your first interview, you were aware that this investigation had already been ongoing with the Tacoma Police Department and that Kelsie Thomas had already made several statements about what had happened, correct?
Correct, in the field. I don't believe she'd ever been at the police department for a formal interview.
During that second interview, well, I guess, let me strike that. During the first interview, because the jury only saw a portion of that, and as your report indicates, Kelsie didn't make any admissions during that first interview, correct?
No, she never admitted to killing Chloe.
During the second interview, when Kelsie finally admitted to actually physically touching Chloe, at first she claimed that she held her down and pushed off of her. Do you recall that?
I do.
And prior to that, you suggested to Kelsie that was a possibility, didn't you?
There were several different scenarios that we discussed with her, possibilities how the injuries occurred to her.
Okay, but if I were to assert to you that Kelsie Thomas never admitted that she held down Chloe or that she pushed off of her until you suggested it to her first, would you have any reason to disagree with me? And again, the recording would be the best evidence of that.
Right, I'd have to refer to the recording.
At one point, you're trying to determine with Kelsie the timing of things, and you told her that it makes more sense that this happened before her nap because she was tired, correct?
Again, I'm trying to recall it specific when that came out. I recall making the statement, her story is now making more sense. I just don't recall specifically when that came out, but that conversation did take place.
Okay. And again, if the transcript of that interview and the recording that the jury just saw,
Objection overruled. Go ahead.
and if all of that was reflected on those recordings, again, you wouldn't have any reason to dispute that?
I think the recording is accurate and stands for what it is.
As far as this taking place before her nap, she adopted that narrative as well, correct? If in fact,
Counsel testifying, mischaracterization of the evidence as well.
Your Honor, can we approach?
No, I'm going to overrule that objection and just go ahead and answer, please.
I'm sorry, Your Honor, can we read the question back?
The question is, Kelsie Thomas adopted that narrative as well, correct? That this took place before her nap?
I think as we went on, it was clear that the incident happened prior, closer to that 1:15 time at nap time.
Now, when Kelsie first made any kind of admission, and that was that she held Chloe down, you told her that we need to make sure that her story is believable, correct?
Exactly, yes.
You told her that there were lines on Chloe's neck that go up the sides of her neck and behind her ears and straight up, correct?
Yes, we discussed that, I think, on both days.
And you told her, I don't want the doctor to say, I think actually she must have came behind her with something and pulled up on her. that's how it happened maybe. You recall telling Kelsie Thomas that.
Yes.
And Kelsie Thomas ultimately adopted that narrative as well, correct?
I wouldn't use the word adopt, but I wouldn't be doing my job if I accepted just the first confession as the full confession.
The idea that Kelsie came up from behind and pulled up on her, you mentioned that before Kelsie ever did.
Again, I'm trying to recall when the chain of events for that coming out. I don't know if that was after she was motioning with her hands, because again, we're having a lot of nonverbal communication with her hands as well. But that idea did come out coming from behind with her with an object.
Okay. And again, the recording would be the best evidence of that, correct?
Yes.
The jury can see whether or not you actually suggested that to Kelsie before she actually said it, correct?
Yes, everything that we did with Kelsie Thomas was on video.
And at that point, you had already attended the autopsy and you know what injuries you had to account for, isn't that true?
Yes, I attended the autopsy and I was aware of the, I guess, injuries to her neck.
Even after Kelsie admitted that she held Cloe down and that Cloe was probably in distress, she continued to claim that she didn't remember Cloe having anything around her neck, correct?
Yes.
And you tell her, okay, do you think, because we're gonna test like the pajama pants that you pointed out for like DNA from skin, is there any way that to make her sell your story that maybe you wrapped that around her neck and held it there for a little bit after she was deceased? And she said no, correct?
Yes.
And so Kelsie Thomas, for hours and hours of interviews, is saying, I found her in those pajama pants. That becomes a question, and then she comes back full circle, and you're telling her, well, maybe you use those pajama pants, correct?
It was clear during the interview that those pajama pants were important to Kelsie Thomas. It was our belief the entire time that those had some sort of involvement in her death.
With your knowledge, knowing that there was evidence of suspension, you asked Kelsie, do you remember lifting her completely off the ground, though? Correct?
I did ask that question.
And that was prior to Kelsie saying that she actually lifted her up off the ground while grabbing her with the pajama pants, correct?
Again, oftentimes I ask questions after I'm seeing her do motions. So if she's given a motion of grabbing and leaning back, I would follow up with pulling her off the ground for a verbal confirmation.
At the end of Kelsie Thomas's interview, you told her that oftentimes people in her situation like to write stuff down to make themselves feel better, essentially, correct?
Yes.
And so you suggested the letter to Kelsie, and Kelsie took your suggestion in that regard as well, correct?
I suggested that she could write a letter. Yes.
After Kelsie Thomas's confession, you had inquired with her whether or not she had actually told anybody else, perhaps a little suspicious as to whether or not she had told her husband Aaron, correct?
That's correct.
And so far as you're aware, Kelsie Thomas never told anybody about this that you're aware, correct? Other than in her interview.
That's correct. That's her statement, and that's Aaron Thomas's statement as well.
I have no further questions, Your Honor.
Can you direct?
A brief moment, Your Honor, if I may. Now, why did you ask about the story needing to be believable?
If in an interview someone admits to a crime and it doesn't match the evidence, we want to elaborate on that. For instance, if I have a gunshot victim with 6 bullet holes and someone says, yeah, I shot that person, I'm going to ask follow-ups, how many times? If they say shot him 1 and there's 6 bullet holes, I have to account for those somehow. Sometimes it's easy just to say I did something. It's harder to elaborate on exactly what I did to cause that person's death.
And why did you challenge Kelsie Thomas with discussions of testing the pants,
In regards to
the pajama pants?
the pajama pants, again, that's a tool that we can use that forensic evidence may exist that's going to link this item to that individual's death. It's one of those instances that people can take, and once they realize that, okay, maybe what I'm telling you, they're going to be able to prove scientifically, I'll own up to it now.
And there was some discussion of your concerns about how Chloe came out of the pants in the first story that Kelsie Thomas gave. That came out in cross, if I recall correctly.
Yes.
In your function as a DCI agent, how many hanging death investigations have you conducted?
At least 6, maybe up to a dozen.
And is that as lead
I'm sorry.
investigator? Is that as lead investigator?
That'd probably be a mixture of both.
In each of these, at least as to the ligature, how would you find it in all those occasions?
Objection, Your Honor. I don't know that this witness qualifies to answer the question.
Sustain.
As far as the letter, why did you give Kelsie Thomas the option to write that?
It's another way for her to express in her own words what she had done in her actions. It's also a chance for her to accept responsibility or indicate if she's sorry for what she'd done.
And was there a time where she talked about what she would say to her family?
She did. She asked me several times what she was going to tell her family.
Nothing further, Your Honor.
Recross.
No further questions, Your Honor.
You may step down. May this witness be excused.
Yes, Your Honor.
You may also be excused and leave the courtroom if you choose to do so. Does the state have another witness available for today?
No, Your Honor.
Is the state resting or not?
We just have one recording, or 2 recordings to play.
Oh, did you want to play those now then?
It's up to Your Honor. Okay. So we will play them now, Your Honor, if we could have a minute. And Your Honor, these would be state's exhibits 88 and 89 that we'd be seeking to admit through stipulation.
Any objection? No, Your Honor. State's exhibits 88 and 89 are received. And are you going to play them one at a time?
Yes, Your Honor.
Approximately how long are they?
Your Honor,
2 minutes, I think, or maybe 3.
Your Honor, the first one's, I think, 6 or 7 minutes from July 26, 2018. The second one is approximately 2 minutes from the following date, July 27, 2018.
Are you going to play them consecutively without going back on the record?
Yes, Your Honor.
Then the jury will listen to the playing of State's Exhibits 88 and 89. The court reporter will not be reporting during that time.
Hello?
Hey,
Hey,
I love you.
I love you too. What is going on?
I'm sorry.
What do you mean you're sorry? What's going on?
I take it any time.
Yeah, I know. I kind of know what's going on. But
I didn't mean to do it, Aaron. And I really hope you believe me.
what do you mean, Kelsie?
I didn't mean to hurt her.
Please tell me you're not telling me what you think you're telling me.
I'm sorry. I didn't do it on purpose. I didn't. I loved her. I love you, and I love Phoenix. It was an accident.
Anything else on the phone?
Huh?
The attorney in the morning.
Uh,
Hear me?
okay. I love you.
I love you too.
Okay. Bye.
Just know
I'm
that,
back.
just know that it was a complete accident.
I do.
And I don't know if you're gonna believe me. I don't know if you're gonna.
Hey, let's just get through what we need to get through, okay? You made a mistake.
Are you gonna divorce me?
Huh?
Are you gonna divorce me?
I don't know. I haven't got that far.
Aaron,
I just had a little girl's funeral today, Kelsie. I need a day.
I know, but I'm so sorry. Don't you the whole freaking family hates me?
Nobody hates you. We understand something happened.
Back on the record, Your Honor.
Back on the record.
Your Honor, at this time, the state rests.
State rests. Members of the jury, we're going to take our weekend break. Please remember all the prior admonitions. Keep an open mind. Don't talk to anyone about this case. Whoever you might be having contact with this weekend, you may not talk about this case. Pay no attention to any media accounts for the entire weekend until we see you again, and for as long as you're a juror on this case. Don't do any investigation of the scene of the incident. Please be back in the jury room at 10:09 on Monday, and I've been asked to remind you that this weekend is daylight savings time, so turn your clock ahead 1 hour at 2 a.m. on Sunday because we want you to be on time for court on Monday. With that, enjoy your weekend.
Our copy of the video.
You're back on the record. The jury has been excused for the weekend. The state has rested. The court's informed that defense counsel will be making a motion for judgment of acquittal. Go ahead, Ms. Jensen.
Thank you, Your Honor. As it relates to count one, the defense asserts that the state has failed to show that Ms. Thomas acted with malice aforethought or that she assaulted Cloe Chandler. With regard to count two, we further assert that the state has been unable to show that Ms. Thomas intentionally committed an act which used unreasonable force, torture, or cruelty that resulted in physical injury or which intended to cause serious injury to Cloe Chandler. As the court is aware, a confession alone cannot warrant a conviction. It must be supported by other proof that a defendant committed the offense alleged. In this case, law enforcement began their investigation based on information that they had obtained from estranged family members who have bad opinions about Ms. Thomas's parenting. Dr. Catalier's autopsy findings ended up being based, at least in part, on that information that she got from law enforcement. However, she also testified that the information she had been given may not have been all of the pertinent information, that she may have only had some information with regard to the two different versions that Ms. Thomas gave law enforcement about how Cloe died. She ultimately determined that the cause of death was a strangulation. She did also testify that there was at least some findings consistent with an accidental hanging. In addition to that, there was no DNA foreign to Cloe anywhere on her person. And I know Ms. Sensick testified that DNA doesn't always transfer, but the lack of that DNA should not be ignored in this case. So accordingly, it's the defense's assertion that there is insufficient other proof to corroborate Ms. Thomas's confession. Therefore, Your Honor, even in considering the light most favorable to the state, there's insufficient evidence in the record to meet the standard of proof beyond reasonable doubt from counts 1 and 2.
Ms. Thomas?
I just heard some discussion. Your Honor, the state would note, as the defense did, that Your Honor has to weigh this motion in light most favorable to the state. I would pose that, at least through the evidence that's actually presented, the investigation did not begin of Kelsie Thomas only upon family members asserting concerns. The concerns were asserted the day after law enforcement began to investigate this matter. The family, as testified, came in on July 20th to discuss matters, beginning with Brittany Johnson, with law enforcement. Law enforcement was already investigating this matter on the 19th. Further, as to claims that Dr. Cavalier's autopsy is somehow jaded and colored by the confession, and somehow because confessions alone are not sufficient evidence to establish a case, I would point out Cavalier did not make a finding that there were indications of an accidental hanging. There were indications in the autopsy of a hanging. That does not mean it's an accident, as was clearly described in the way that Kelsie Thomas confessed. There is suspension in this form of strangulation. But strangulation doesn't just refer to one form of asphyxia. It refers to hanging, it refers to manual strangulation, it refers to ligature strangulation. And Dr. Cavalier's testimony indicated there are presences of all three, and she went through those at length, which admittedly was at significant length. She makes it clear that the physical findings do not align with a child hanging, either by accident or by intention of that child. A ligature is required in the manner that she saw the injuries. Manual strangulation may take a part of that, but regardless, her testimony in the view most favorable to the state would clearly indicate the hand of another involved in Chloe's death. As far as intent, Kelsie Thomas clearly stated in her confession she strangled her own daughter. She did so out of a desire to have Chloe stay in her bed, that she was just so angry, she just wanted her to stay there. She intended to carry out those acts in a manner that was incredibly reckless, incredibly inappropriate for a child of that age. Her actions that she chose to do by her own volition and her own anger led to the death of that child. That in itself is enough for the jury to surmise a malicious intent. But even so, the way she describes continuing the strangulation, the way she describes seeing her own daughter's eyes bulge, also indicates a malicious intent as she proceeds to continue to take the life of Cloe Chandler. It is clear that she was a person in custody of this child. This child was alone with her, along with another child, at the Kelsie Thomas residence. The state has ample evidence to establish its case, to survive this motion, and to present its evidence to the jury for their evaluation and findings. So for those reasons, Your Honor, we'd ask for you to deny the defense's motion and ask for you to allow us to proceed with the case to submit it to the jury.
Considering the evidence in the light most favorable to the state, which is the legal standard at this juncture, the court finds sufficient evidence to send this case to the jury. The motion for judgment of acquittal is denied. That completes the evidence for today.